Good morning, Sabah al-Khair. I'd like to welcome everyone who is joining us today to our debate under the title, Who is Protecting Palestinian Workers in Israel? To be more precise, what are the gaps in the enforcement of Palestinian workers' labor rights? My name is Einat, and I'm a board member of Kav LaOved, a workers' hotline organization who is hosting this debate together with the NRC, the Norwegian Refugee Council, who has been supporting Kav LaOved's efforts in protecting Palestinian workers in Israel generously. Before we begin, I would like just to mention the debate will take place in English and in Arabic. So for those of you joining us via Zoom, you can see on the bottom of your screen the globus icon where you can find the interpretation channels, and you can choose if you would like to hear us in English or in Arabic. Khaled, can you shortly repeat what I just said in Arabic? You're muted.
صباح الخير للجميع. المؤتمر اليوم هو باللغتين الإنجليزية والعربية. اللي بده يشترك باللغة العربية بيقدر بس يكبس بالكمبيوتر على الترجمة باللغة العربية وبيسمع الصوت باللغة العربية. شكرا للجميع.
شكرا حمد. So let me shortly just introduce you, our dear panelists who will shortly be joining us. We have with us today Professor Kenneth Mann, the Executive Director of Legal Aid for Palestine and an Associate Professor of Law at Tel Aviv University. Khaled, which you just saw briefly, was Kav LaOved's advocate who was coordinating and managing the Palestinian Workers Department. Michal Tajer, the head of Kav LaOved's Legal Department. Abed Dari, Kav LaOved's Veteran Outreach Worker. And Michal Korech, Kav LaOved's Research and Public Policy Manager. So just shortly before we start, a few technicalities. We will first have our panelists sharing with us their insights, and then we will open the stage for questions from the audience. So you can probably already see in your Zoom chat room or in Facebook's comments, we've shared with you a link that will enable you to send us questions throughout the event. And after the panelists, the speakers will finish, we will go through the questions and they will probably do their best to answer all of your questions or needs for qualifications. And we are a bit short with time, so let us jump right into the content. I'll just shortly start by framing our discussion and say that the focus of this brief will be Palestinian workers within Israel 48 borders, or as we define it in Kav LaOved, the occupation of labor, meaning it is impossible to our belief to understand the exploitation of Palestinian laborers outside of the context of the occupation. In this regard, we believe that the dismantling of economic mechanisms that sustain this exploitation of Palestinian workers is essential for the ending of the occupation. For us, demanding the state to protect and ensure Palestinian workers' rights is equals to demanding the state to be accountable. And accordingly, we chose in this panel to focus on the gaps in enforcement of Palestinian workers' labor's rights, highlighting three main aspects: the recent reform in the model of employment, the lack of enforcement of labor rights, and the disregards for safety standards in their workplace. Let me invite our first speaker already to join us on screen, Professor Kenneth Mann. I'll shortly introduce you, Kenneth. Hello.
Hello.
Kenneth, as I mentioned, is the Executive Director of Legal Aid for Palestine, which provides legal aid to West Bank Palestinians who have problems obtaining or holding permits to enter Israel for employment. He's an associate professor of law at the Tel Aviv University and conducts his research on Palestinian permits, litigation, and administrative courts. He's also the chair of the board of Gisha, a legal center organization focusing on freedom of movements for Palestinians. And he's the founder of the Israeli Public Defender System, providing legal aid to suspects and defenders in criminal cases. Quite a record, Kenneth. You will be talking to us about the government's system of employment, focusing a little bit on the recent reform that was implemented a year ago. I'll give you the stage.
Yeah, thank you very much. And thank you to Kav LaOved and the Norwegian Refugee Council for this opportunity to address these important questions. To enter Israel and work, Palestinian workers must find licensed Israeli employers who agree to register them with the government agency responsible for controlling the number of workers who can enter Israel, which today, just for discussion, is approximately 100,000. However, most Palestinian workers are prohibited from entering Israel without a permit to look for work, so they have no direct access to Israeli employers. To deal with this problem, middlemen, and I'm going to be talking a lot about them now, supply names of Palestinian workers to Israeli employers who have been licensed by the government to employ Palestinian workers, and these employers then can register the worker with a government agency. A large proportion of Israeli employers who employ Palestinian workers will not provide a job to a Palestinian worker unless the worker's name is supplied to the employer by a middleman. The result is that these Palestinian workers are dependent on middlemen to find them work with an Israeli employer. Approximately 40 to 50% of Palestinian workers pay middlemen up to 1/4 of their monthly salary for each month they are employed, not just the first month, but for every month. Thus, if a Palestinian worker received from his or her employer 8,000 shekels per month, the worker would have to pay to the middleman 2,000 shekels each month. Building on this example, if the middleman supplied 20 workers a year only to licensed employers, the middleman would receive the equivalent of over $150,000 paid by Palestinian workers out of their pockets, half of which the middleman gives to the employers. So the employers and the middleman divide more or less this payment that the Palestinian workers have to make. The middlemen and the employers share the profit. You can see in this system, the licensed employers are actually paid by the middlemen for restricting their employment of Palestinian workers, those workers whose names are submitted to them by the middlemen. This corrupt relationship allows the middleman a huge amount of control over Palestinian workers' access to Israeli employers. The middlemen operate in the cross-border marketplace for Palestinian workers where there is little law enforcement against illegal practices. This phenomenon creates a very unbecoming picture on the West Bank. Middlemen advertise on Facebook that they are selling entry permits for entry into Israel for work, making themselves the middlemen into the portal through which Palestinian workers must go through to get work in Israel. Due to the large incentive that employers have for hiring workers only through middlemen, because they're dividing the profits, many licensed employers who need less than the number of Palestinian workers who they are entitled to employ under government regulations falsely report to the government that they are employing in their own business all the workers whom they are entitled to employ. However, what actually happens, without disclosing this to the government, these employers send the extra workers to unlicensed employers who pay the licensed employer who pays the worker. This is clearly a violation of the rule that only licensed employers can hire Palestinian workers. The impact of this is to expand the hold of middlemen on Palestinian workers and increase their ability to sell at high prices entry permits. If the workers leave their employer because they are being mistreated or because they have been fired or for any other reason, they lose their entry permits because the employer reports the absence of the worker to the government agency. The employer thus has the power to cancel the worker's entry permit and essentially their ability to work. The workers also lose their place on the list of Palestinian workers who are included in the quota of 100,000 now, making them not only unemployed, but probably, or in many cases, unemployable. This system of employment bears essential qualities of what is known as a binding agreement between worker and employee. In this case, imposed on the Palestinian worker in a situation in which all the power is in the hands of the employer. The workers are bound because if they want to be sure of holding their permits and their place on the quota list, they must remain with their employers and continue to pay the middleman. This binding agreement, a term which has become known throughout the use of foreign workers and workers in situations in which they have no essential rights in the place where they work, is a situation which is akin to or like what is defined as a vertical cartel in the Israeli restrictive trade practices law, which would make it unlegal as preventing competition among employers and workers for places of work. But this accusation has never been made officially by any Israeli law enforcement agency. It is also a violation of the terms that employers must comply with when they obtain their licenses from the government to employ Palestinian workers. In addition, the licensed employer's false report made to the government about the number of workers employed in their own businesses is an offense of fraud on the government and also punishable under the criminal law. So this is a situation that the reforms, which I'm going to talk about now, addressed. The relevant government agencies who are supposed to regulate this area came to recognize that there were serious problems with the dependence of Palestinian workers on middlemen. And in 2017, the government called for reforms. The Israeli controller, the Bank of Israel, and the ILO also published critical reports. Wakaf Andan and Hagai Etkes, in a report for the Bank of Israel in 2019, provided important data on the cost of these practices to Palestinian workers and the Palestinian economy, increasing the pressure for reforms. Then in December of 2020, December of 2021, just a few months ago actually, Wapak Andel and Hagai Etkes wrote a report for the Israeli National Security Studies in which they showed that the reforms, which I'm going to describe immediately, had failed and the illegal trade in entry permits continued, substantiated by information we had collected through our own work from workers that they continue to be dependent on middlemen. Why did the reforms fail? One of the reform measures is the following. When work permit holders are fired or leave their work, their permit to enter Israel is still canceled, like it was in the past. But unlike before the reform, now they remain on the quota list of 100,000 workers who are eligible for work permits. And this is for 2 months after leaving the work and losing the entry permit. During this 2-month period, they are entitled to get a special temporary permit for up to 14 days to enter Israel to search for a new licensed employer. If after these 2 months, the worker does not find a new job with an Israeli employer, the worker is removed from the eligible quota list. If the workers find new work, they are reissued a work permit. What is the impact of this change? Allowing the workers to remain on an eligible list of workers gives those workers an advantage vis-a-vis other Palestinians seeking work in Israel who do not have a permit, because for 2 months, the worker who lost the permit retains the right to be one of the Palestinians included in the 100,000 workers, and they can look for work. So you have to see that there's a list of 100,000, and that list, when it's full, no other Palestinian is entitled to get a work permit. So if a person loses his or her job and is removed from the list is then open up for somebody else to come into. Under the new revised measure, a Palestinian worker who loses his or her job, can stay on that list for 2 months, which is supposed to allow them to come into Israel for short periods of time and try to get work. However, the impact of this change was not what the government agency who published and instituted the change thought it would achieve. Allowing the worker to remain on the eligible list of workers gives this person an advantage over other workers, but it did not change the workers' dependence on the middlemen, because this reform had no logical or practical impact on the power of the middleman to control access to Israeli employers. So the person who had lost his job and had 2 months to look for a new job still had no way of finding the employer without going to a middleman. So that change failed. A second change removed the limitation on the number of Palestinian workers that Israeli employers are allowed to register as working at their businesses. Before the reform, the corrupt employers who were willing to falsely report that they were employing workers at their business, but they were not because they were giving them to other unlicensed businesses, were limited in their ability to do this, to inflate the numbers by the limit that the government had put on the number of employees for whom they could get a permit. So what happened? The removal of the limitation on the workers that these employers can report as being employed by them actually increased the leverage of the employer to sell entry permits. The taking off of the cap has expanded the power and has increased the power of employers working with middlemen to create a market in entry permits for which the Palestinian workers have to pay up to a quarter of their income. Why has this exploitation continued even after reform? The reform measures as they were designed cannot remove the power held by the middleman to restrict and control access to Palestinian workers to employers. So long as Israeli employers prefer to work through middlemen because they receive a large financial kickback from the middleman, Palestinian workers will continue to be subjected to illegal binding agreements, and employers will continue to make false reports to Israeli government agencies. Presently, in the offices of the government who are charged with regulating Palestinian access to Israel for work, there is no commitment to investigation of employers and almost no imposition of fines or other sanctions. Law enforcement means committing resources to identifying employers involved in this oppressive system and filing administrative or criminal complaints. There can be no doubt that the Israeli government agencies responsible for employment relations would not tolerate a system for Israeli employees where they had to pay 25% of their monthly income to a middleman to remain employed. In the employment of West Bank Palestinians in Israel, there is therefore a deeply disturbing discrimination against Palestinian workers. Dealing with this problem requires creating the circumstances in which Israeli government agencies take seriously the dignity of Palestinian workers and their right to be treated equally on the basis of the norms and laws that apply to Israeli workers, which in the absence of labor unions and strong bargaining power that protect Palestinians can only be achieved through an assertive program of law enforcement using stiff administrative penalties and often criminal law. focused on the employers who are violating the law. In closing, I will mention that the NGO LEAP, Legal Aid for Palestinians, of which I am the executive director, provides legal aid to West Bank Palestinians in its office on the West Bank, Palestinians who have difficulty obtaining and holding entry permits in the context of this very problematic system of employing Palestinian workers and issuing them work permits. Along with the NGO MAN, LEAP is also calling for a fundamental revision in the permit system, which would result in issuing to West Bank Palestinian workers green passes, which I can't describe now in the time we have, that would to some extent help the workers get free of the binding agreements. But nonetheless, the government has to come into the picture with investigation and enforcement sanctions. Thank you.
Thank you, Kenneth, for this important, albeit gloomy insight. I'm sure we're going to come back to you, especially with the closing remarks on talking about what can be done in order to tackle the current situation. But we are a bit short in time, so I will briefly introduce our next two speakers. Khaled Douhi, the manager of Kav LaOved's Palestinian Workers Department, which assists Palestinians working in Israel to restore violated labor rights. In his capacity is also a coordinator of Kav LaOved's work parallel to the Palestinian Ministry of Labor. And he will be sharing with us voices and testimonies of workers on the ground. Right after Khaled, we will have Michal Tajer, which I mentioned already is Kav LaOved's lead advocate. And among the prominent High Court of Justice cases that she was leading in recent years, we will have find the appeal for the reform of the pension funds and sick leaves for Palestinian workers, and the recent reform we just heard about from Kenneth in the permit system and the demand for its implementation. So Michal will share with us some legal aspects and addressing Palestinian labor rights. So Khaled and Michal, welcome on board. Khaled, we would like to ask you first to share with us the experience of workers. We just heard from Kenneth a very gloomy description of the daily life, the hopes we had from the reform, the fact that it's not implemented. So what can you tell us that you hear from workers themselves? What kind of impacts the reform had? And afterwards, of course, also beyond the reforms on their ongoing experiences. Khaled, you are muted.
No. صباح الخير. Thank you. Good morning for all. صباح الخير للجميع. أنا بالبداية يعني بدي أشكر الجميع على الحضور، جميع المشتركين، وبدي أشكر شكر خاص مؤسسة NRC اللي يعني بتدعم حقوق الإنسان بشكل عام وحقوق العمال الفلسطينيين بشكل خاص، وهذا إشي مهم جدا وجودها ودعمها لنا وللمؤسسات اللي بتدعم العمال الفلسطينيين، لأنه بالآخر بيرجع بالفائدة على العمال نفسهم. أنا يعني البروفيسور كينيت حكى بشكل موسع عن الأشياء النظرية بالريفورما أو بالتعديل اللي صار على العمال وبالأشياء النظرية كيف الأشياء بتطبق نظريا. أنا بدي أحكي يعني أكون شاذ شوي اليوم، وبدي أحكي عن الأشياء العملية اللي إحنا بنشوفها بشكل يعني فيزي بشكل مباشر وجه لوجه مع العمال من خلال يعني تجاربنا وتواجدنا مع العمال في كل مناسبة مع العمال نضل نكون معهم. يعني إحنا بنتواجد مع العمال أيام السبت اللي هو يوم عطلة أسبوعية عندنا ويوم العطلة بتاع العمال، يعني ما في لنا مجال ثاني نتواجد مع العمال بمكتب إلا غير خلال يوم السبت، وعملنا جهود مكثفة اللي مكتب العمل الفلسطيني وزارة العمل الفلسطينية يفتحوا مكاتبهم عشان نقدر نقابل العمال ونتواجه معهم وجه لوجه ونسمع منهم وجه لوجه، لأنه التلفون بيختلف، الكتابة عن طريق الفيسبوك أو عن طريق الإيميل بتختلف من انك انت تتطلع بعينين العامل باربع عينين وتسمع منه وتتطلع على تقاسيم وجهه. يعني احنا عمالين بنلاقي طرق ثانيه اللي احنا نتواجه على المعابر وقت ما العمال بتروح من عملها، اللي نقدر نحكي معهم، لانه بساعات الصبح صعب كثير انه نحكي مع العمال ونقدر يكون معنا وقت نحكي مع العمال ونقدر نفهم منهم الاشياء. فعشان هيك من تجاربنا أنا يعني بدي أقول للأسف إنه تطبيق جديد ما لاقى نجاح. بالعكس يعني هو عمليا فشل بأرض الواقع. يمكن هو ككتابة وكمسودة هو ناجح، بس تنفيذه بأرض الواقع هو فشل تام، لأنه لا يعقل إنه المشغل هو اللي فقط بيقدر يختار العمال والعمال ما بتقدر تختار المشغلين. يعني الآلية مش كاملة، يعني فيه بعد عدة ثغرات بالتطبيق هذا على أساس إنه طريقه للنجاح. يعني أنا حسب رأيي وقلت عدة مرات في مناسبات سابقة، أول سبب لفشل هذا التطبيق أو تطبيقات ثانية مستقبلية راح تكون وجود دائرة المدفوعات الإسرائيلية في الصورة في تطبيقها الحالي، اللي هي بتطلع قسائم راتب، واللي هي يعني بتاخذ تقارير من المشغلين وبتطلع حسب هاي التقارير قسيمة راتب للعمال. يعني هاي هي آلية اللي بتساعد والداعمة لفشل أي هذا التطبيق ولا تطبيق مستقبلي اللي بده يصير كمان إذا راح يصير كمان تطبيقات مستقبلية. والآلية مش كاملة طول الوقت إن العامل المشغل الإسرائيلي يدفع للعامل الفلسطيني أجاره نقدا ومش مسجل ومش مصرح. هذا كمان يعني إشي اللي هو داعم لفشل هذا التطبيق وتطبيقات الثانية. والإشي المهم جدا اللي إحنا عاملين بنحاربه، أنا لقيت فيه شخصيا يعني خالد فشل كبير، ويعني متأسف إني أحكي عليك، بس منيح إنه الواحد يعترف بالأخطاء تاعته. يعني مش أخطاء شخصية تاعتي، بس أنا يعني قديش حاولت وقديش حاربت يعني ما قدرت أنجح بهاي النقطة، اللي هو عمليا بعدهم في سماسرة تصريح. سمارة التصريح إني مصاصين دماء العمال الفلسطينيين. هاي هي الكلمة المضبوطة اللي أنا بقدر أحكيها. يعني لا يعقل إنه في أراضي السلطة الفلسطينيين سماسرة التصريح بيعلنوا بنشروا حالهن زي ما واحد بنشر منتوج معين وبسوقوا هن بنشروا حالهن والإشي مباح. وهذا يعني في ظاهرة، يعني في إسا بقدر أقول تفاؤل شوي نسبي بسيط أنا قدامي، إنه يعني المسؤول عن التشغيل الداخلي في وزارة العمل الفلسطينيين يعني هو مش مجتهد جدا وعمال بحارب هاي الظاهرة. يعني إحنا بتواصل يومي تقريبا لمحاربة هاي الظاهرة عن طريق سن قانون جنائي للعمال، يعني لمنع ظاهرة السمسرة وظاهرة بيع التصريح. ففي حالة إنه إحنا بنوصل قانون جنائي في أراضي السلطة الفلسطينية منع هاي الظاهرة، وفي حال إنه دائرة المدفوعات الإسرائيلية تتغير وبتغير شغلها وبترجع لهدفها الأصلي اللي هو حماية حقوق العمال الفلسطينيين، وبحالة إنه بصير تغيير جذري في دفع الأجرة العمال الفلسطينيين عن طريق شكات أو عن طريق دفع تحويل الحساب مباشرة للعمال الفلسطينيين حسابهم في أراضي السلطة الفلسطينيين. هاي الأشياء مع بعضها يعني نربطهم الثلاث أشياء حسب رأيي مع بعضهم بنلاقي إحنا تقريبا حل أو في يعني بوادر نجاح للتعديل وتشغيل العمال الفلسطينيين في داخل الإسرائيليين عن طريق اللي هو بيختار العامل. يعني مصيره بإيده بيصير عمليا، وبتصير منافسة بين المشغلين الإسرائيليين، وبيصير حق الاختيار للعامل الفلسطيني، يعني إنه يختار المشغل اللي هو بده إياه. طبعا كثير من الناس بتجهل وكثير من المؤسسات بتجهل إنه يوم العامل الفلسطيني هو ببلش على الساعة 3 الصبح وقت ما هو بيستيقظ. يعني أنا مثلا لازم أكون في جمعية عنوان العامل على الساعة 9، فأنا ببني إني أنا مثلا مسافة الطريق نص ساعة أتحمم نص ساعة، يعني 8 أنا بفيق. بينما العامل الفلسطيني حتى إنه يبلش عمله على الساعة 6 أو على الساعة 7 الصبح، هو لازم يفيق على الساعة 3. يعني عنده شجار ببلش أول ما بفيق لتنه يوصل المعبر. المعبر ببلش شجار ثاني اللي هو كيف بده يجتاز المعبر بأمن وسلامة بلا ما يختلف مع العمال الثانيين اللي هن نفس الوضع معه. ثالثا بده يطلع المعبر، بده يستنى السفرية اللي بتستناه أو بده يلاقي سفرية حتى يوصل لورشة العمل في تل أبيب أو بأي محل. يعني عمليا هو كثير أيام العمال، كثير عمال حكوا لنا إنه كثير أيام بفيقوا وبروحوا وما بيشوفوا أولادهم بهذاك اليوم. يعني عمليا هو بيطلع الصبح وبيرجع المغرب، وفي كثير أيام بتنفد عليه اللي ما بيصير له اللي يحكي مع ابنه كلمة أو جملة. وهي الأشياء يعني اللي الناس بتجهلها. يعني عمليا هي إشي غريب. يعني كل بني آدم لازم يشوف أولاده يوم عمليا. في كثير أيام تنفذ على العمال الفلسطينيين اللي ما بيصير لهم وما بيحظوا يشوفوا أولادهم. إحنا يعني بالمشروع الفلسطيني عمالين بنشدد إنه في عائلة بتستناك، ارجع لعائلتك بخير وبسلامة. يعني يوم العامل الفلسطيني ببلش الساعة 3، على الساعة 11 هو بيكون تعبان. فإحنا دائما بنحذرهن وبنوصيهن إنه في عائلة بتستناك، في زوجة، في أولاد، في آباء وأب وأم بيستنوك. ارجع لأولادك بخير وبسلامة، ودائما اتبع وسائل الوقاية والسلامة. فهي هي التحذيرات اللي احنا بنشدد عليها. يعني عمليا احنا بشغلنا عمالين بنحاول، ما بدي اعالج عامل فلسطيني مريض اللي ما بيعرف حقوقه، انا بدي اوعي العامل الفلسطيني بمعرفة حقوقه عشان انه يظل متابع الاشياء ويظل هو على حقوقه وعلى صحته وسلامته. وشكرا كثير كمان مرة للمحاضرين، وشكرا كثير للان سي او اللي بتشتغلنا وبتدعمنا. شكرا كثير.
Thank you, Khaled. It's a very short, sorry, we had to cut you short, but thank you for this human point of view also of the experience of the workers. Michal, I would like to immediately jump to you, complementing the picture we just heard from Kenneth and Khaled talking about the legal aspects. And I mentioned before that you had petitions trying to challenge, to mobilize the authorities to be accountable, to implement their enforcement. What can you tell us from your perspective of what enables this ongoing violation of the labor rights? And you're muted, Michali.
Sorry, yeah. Okay, hi, hello everyone. I would like to say, first of all, that what Kenneth talked about, the regime of employment, and what Khaled talked about, also the checkpoints, the employment regime, the permit system, the mediators, middlemen that collect money, all of it is, of course, part of the bigger picture of the violations of workers' rights of Palestinian workers. I think the Palestinian issue is especially frustrating in some ways, even though in the legal aspect it is quite an optimistic way to see that legal work can change things for these workers. Unlike the general issues of occupation, which I do not believe in the legal system ability to change fundamentally the issues. I think in workers' rights, in Palestinian workers' rights, we had a good experience in changing things. Part of it because of the huge gap, which I want to start by trying to explain, the huge gap between the Declaration of Equality of Workers' Rights basically was established in a governmental decision in the 70s, a cabinet decision, that equalize their condition of work to those of Israeli workers. So this declaration enabled some kind of very good basis, legal basis to start with. And of course, as the years passed and quite from the beginning, the violations and the gap between the reality and the declaration was huge. But it enabled a lot of things to work with. So basically, in order to explain, I think what Khaled says from the daily perspective, and in order to explain the violations of rights, it's important to introduce two main political interests in the employment of Palestinian workers in Israel. First of all is the political context of the occupation, of course, that developed into this permit regime Kenneth talked about. This permit regime became a central a tool to management of the Palestinian workers in Israel, and became some kind of a tool of the reliance to the population and the economy of the Palestinian Authority on the Israeli market. And this context of occupation also was the formal justification of a lot of restrictions on workers, including freedom of movement, as Khaled explained, the regime of obtaining the permits, the regime of binding to an employer. It was excused as a way of control the place where the Palestinian worker is in every second of the day, in order for him not to be a security hazard, etc. So this has a lot to do, of course, the binding and making the employer a kind of safeguard to his workers, of course, gave a lot of power to the employers on top of the regular power within the employment and relationship of employer and employee, of course. So this is one aspect of that really had a lot of influence on the non-power of negotiations of workers. And creating violations of labor rights. Of course, the other aspect, political aspect, is the economic context. Okay, and it's basically what we need to understand is the average wage of Palestinian workers is around from the 90s is lower in around 40% of the average wage of an Israeli worker in the same occupation. So basically, well, I only have 4 minutes, but I wanted to introduce those two elements in order to say that those two elements, the political context, created a huge gap between the declaration of equality of workers to the situation in itself. And one more aspect, which was part of the control, was that some of the rights were actually controlled by a special unit, payment department within the Israeli authorities. It was established in the 70s and few changes during the years. Right now, it's within the Ministry of Interior. This department was first established in order to fulfill a supervisory role in guaranteeing workers' entitlements to benefits and the equality with Israeli workers. Over the years, in a very, very frustrating example of government misuse of power, this specific unit created violations in its own in its own way. First of all, it conducted a pension fund, which did almost never give any pension. The other example is sick leave. It was supposed to give a compensation of sick leave to workers. Also, it gathered hundreds of millions of shekels within the Israeli government's packets, which were not used to give the workers rights in the end. In all these issues, those are very small, very large issues and very small. I have very little time to explain, but just saying that in these issues, we submitted a petition and we've done legal work that actually created, first of all, a professional pension fund, which will start to operate soon, and also a decision and some kind of use of the payments for sick leave of Palestinian workers. So I'm sorry it was very short, but everything could be read in our reports and website. Thank you very much.
Thank you, Michal. And I apologize for all of this because it's a very hard task to explain shortly such a complex system, and there's so many aspects and to tackle. Since we're really a little bit late with time and we do want to leave space for questions for the audience, I will jump directly to our two final panelists, Abed Dari and Michal Korech. Michal, I would like to start with you because here we're going to focus on this panel on a very specific, on another aspect we still didn't hear in details about, and that's the safety and the regards for lives of the Palestinian workers. Michal Korech is as I mentioned, the manager of the Research and Public Policy Department in Kav LaOved, and prior to her job in Kav LaOved, she was a journalist working in Haaretz, in Ma'ariv, as well as freelance. Michal is being part in the last couple of years of the very intensive efforts of Kav LaOved to monitor closely work accidents in the labor market in Israel, and with a very sad but clear focus on construction sectors and the fatalities of workers, mainly Palestinians, in this area. Michal, can you tell us a little bit which authorities are responsible in Israel for the safety of workers and how does it impact Palestinian workers?
Okay, in order to understand the context, it is worth putting a few numbers on the table. In Israel, there are about 100,000 construction workers. A third of them are Palestinian workers. And the construction sector is the most dangerous one, leading in the number of work accidents. Like in last year, it was 50% of the work accidents. In previous years, it was much more. Meanwhile, the number of Palestinian workers killed in work accidents is 30%. Another third are Palestinian citizens of Israel. When it comes to injuries, we have no accurate information about the identity, but we can say with a high degree of probability that many of them are Palestinian workers because most of the more complex and more dangerous jobs are done by Palestinian workers. In Israel, the authority responsible to enforce the safety of workers is the Occupational Health and Safety Administration, which is currently under the Ministry of Economy. Alongside is PELES, a police unit which was established in 2018 with the aim of investigating work accidents. In this talk, I will address three main points: enforcement action and resources, deterrence tools, and criminal investigations. The resources the state invests per safety administration are quite limited. There are about 80 inspectors at best who need to oversee safety conditions at more than 1,700 work sites within each of more than 1,300 construction sites. It's an impossible mission. This number of inspectors is very low in comparison both to developing and undeveloped countries. The range of inspectors should be between 1,800 to 3,400. 180 and 340 inspectors. The Ministry of Economy is currently examining the possibility of integrating local authority in increasing the effort to enforce safety at work sites. This move can significantly increase the resources available and be significant change. We look forward to see if it really will happen. Moving forward to deterrence tools, there are three main ones: safety orders, work site closures orders, and financial sanctions. These tools can lead to another major deterrent tool that we at Kav LaOved have worked to promote: the revocation of a contractor's license by the Registrar of Contractors. To a contractor who received numerous safety orders and is a serial safety offender. Kav LaOved has led a legal struggle to ensure transparency of safety orders and work site closures orders issued to contractors. This was successful, yet these orders are not accessible to the public in a way that allows the public real examination of the offenders. So in the last month, we started publishing on our website a table of all issued safety orders in real time, making this information transparent. It is critical in getting the public to be aware and involved. Furthermore, we have analyzed safety orders showing that although the Safety Administration stated that they passed to the Registrar of Contractors information on each company with more than 10 safety orders, since 2017, only 66 companies have been transferred, while in the same period of time, 271 companies received more than 10 orders. It should be noted that the Registrar of Contractors who received 66 names, as mentioned, as of December 2081, has addressed only 49 contractors. Unfortunately, Kav LaOved analysis shows that the vast majority of contractors, including those who are licensed, were suspended or conditionally suspended, continue to commit safety offenses. And there is a procedure that monitors, and there's no procedure actually that monitors these companies. Just a few months ago, a worker was killed at the construction site of a company whose license was actually suspended and continued to work in this area too. We continue to work and ensure that sanctions by the Registrar of Contractors will have more impact. Another body with the capacity to promote safety is Palace Unit, as we said, established in 2018, responsible for holding criminal investigations in the field of occupational safety in Israel in all industries. At Kav LaOved, we reviewed the work up to mid of 2021 and found out that since its establishment, the Palace Unit has investigated only 4% of the accidents documented in Kav LaOved. Sum up the picture, we have a situation where, in parallel to what Michal talked about of the non-enforcement of workers' rights, authorities show indifference for human life. And there are no enough resources and no real efforts to ensure workers and health security. We really hope the effort to improve the work of the authorities will be fruitful and that with the safety workers will really be improved.
Thank you, Michal. Abed, are you with us? I think you see you're still muted. Abed, I will shortly introduce you again. He's a veteran outreach worker, situated mainly in East Jerusalem and in the West Bank. And before joining Kav LaOved, for over 14 years, he was the staff coordinator in Bet Hanina Association, promoting community organizing in East Jerusalem. In his daily work and daily life at Kav LaOved, Abed supports Palestinian workers employed in Israel in accessing their rights, particularly in cases of work accidents. So Abed, let's hear from you a little bit about what is the situation you see on the ground, and if you can also add a little bit the aspect of what is the impact of these accidents on the workers and their families. Go ahead.
يسعد صباح الجميع. موضوع إصابات العمل سواء المميتة أو اللي بتخلف عاهات ومشاكل صحية بالنسبة للعمال الفلسطينيين هي تعتبر تحدي كبير لكل من يعمل أو يراقب هذا المجال. ليش؟ لأنه الوضع الطبيعي والواجب عليه في حالة إصابة العمل، فإن القانون العمل الإسرائيلي بيحدد أنه كل عامل فلسطيني مصاب في مكان عمله يتم نقله إلى المستشفى الإسرائيلي أو حضور سيارة الإسعاف إلى مكان العمل للتعامل مع حادث العمل بأقل الأضرار. بعد ذلك العامل الفلسطيني استكمل علاجه في المستشفى الإسرائيلي، وفي نهاية علاجه يتقدم لمؤسسة التأمين الوطني بالمطالبة بدفع مستحقات الإصابة والأيام المرضية بدل الأدوية اللي صرفها. كذلك إذا كان في عنده عجز تدفع له بدل العجز. هذا الوضع الطبيعي والمفروض يكون لأي عامل فلسطيني بيشتغل داخل إسرائيل. لكن الواقع واللي بحدث في معظم حالات إصابات العمل إنه حالات قليلة جدا يتم التعامل معها بالشكل الطبيعي والصحيح اللي حكينا فيه، احضار سيارة إسعاف وعلاج داخل إسرائيل. اللي بيحدث اليوم ولحد اليوم بيحدث يعني إنه كثير من حالات إصابات العمل للعمال الفلسطينيين في حالة حدوث إصابة عمل لديهم يقوم المشغل الإسرائيلي بحمل العامل إلى أقرب حاجز عسكري قريب لمنطقة سكن العامل الفلسطيني وبوجهه لتلقي العلاج في مناطق السلطة الفلسطينية، كله إنه توجه إلى العلاج في منطقة السلطة الفلسطينية. بعدها العامل اللي بيتوجه لمناطق السلطة الفلسطينية بتلقى العلاج داخل مناطق السلطة الفلسطينية، بدخل في متاهة العلاج وتكاليفه على حسابه. عدم تعرف المشغل أو اعتراف المشغل بأنه تصيب عنده، بدفع من جيبه الخاص، وبعدها إذا بده يقدم لمؤسسة التأمين الوطني لإصابة العمل عليه تعبئة أوراق مطلوبة قدمها لمؤسسة التأمين الوطني الإسرائيلي للاعتراف بالإصابة لتغطية أيام المرض وتكاليف العلاج. بنواجه حالات عديدة في إصابات العمل فإنه مشغلين كثير ما بتعرفوا على العامل في إصابة العمل وبنكروها. هذه ناتجة عن عدة عوامل وعدة مشاكل. السبب الأول إنه كثير من عمالنا هم بيشتغلوا في إسرائيل بدون تصاريح عمل، تهريب، وبالتالي أي مشغل إسرائيلي بيشغل هذا العامل أول كلمة بقول له أنت تهريب وما بطلع لك وبخاف وبديش أخبر عنك إنه أنت صابت في مكان عملك، وبالتالي العامل بيروحوا على منطقة السلطة الفلسطينية بفقد كل الحقوق. السبب الثاني إنه التصاريح اللي بتكون بحوزة العامل هي ليست صادرة من نفس المشغل، هي من سماسرة. زميلي كينيث والأستاذ خالد حكوا عن ظاهرة السماسرة اللي هي ظاهرة مش بس بتأثر على الوضع العام للعمال الفلسطينيين، بتأثر على قضايا إصابات العمل مباشرة، بحيث إنه العامل بتوه في إصابة العمل إنه هل أنا بشتغل لدى السمسار اللي بعني التصريح أو لدى المشغل نفسه الحقيقي. هذه إشكالية بنعاني فيها في إصابات العمل. كذلك الأمر السبب الثالث إنه عدم رغبة المشغلين في الإفصاح وإصدار تقارير عن وجود مشاكل وثغرات في بيئة العمل من ناحية السلامة والأمان، حيث إنه مش مستعد يخبر عن إصابة العمل خوف إنه يتم مراجعته من قبل الوزارات المسؤولة عن ذلك. إذا إحنا بدنا نتطلع كيف تحسين الوضع لعمالنا في حالات إصابات العمل، بدنا نشدد على قضية رئيسية ومهمة وضرورية، إنه العمالنا الفلسطينيين الذين يصابون بالعمل سواء مع تصريح أو بدون تصريح، بيشتغل عن طريق سمسار أو أي طريقة ثانية بيشتغل فيها، في حالة إصابة العمل عليك طلب سيارة الإسعاف لتقوم نقلك من مكان عملك. بنشدد على هاي القضية إنه لازم الإسعاف يقوم بنقلك من مكان الإصابة حتى يتم توثيقها بشكل رسمي، يتم نقلك إلى أقرب مستشفى أو عيادة إسرائيلية داخل إسرائيل، والتبليغ بحيث إنه العامل يقول إنه أنا أصبت في مكان عملي، لا يخاف من المشغل، لا يخاف من الاعتقال لأنه بدون تصريح، ما يخاف من كل هذه القضايا، يركز على موضوع واحد إنه أنا أصبت في مكان عملي، ويصرح للطبيب الخاص اللي بيأخذ منه الإفادة. حتى في حالة التقرير يطلبوا من المستشفى يقول يتأكد إنه نسجل إنه هاي إصابة عمل، لأنه هذه القضية بتساعد العامل على إنه يثبت حقه في انه يحصل حقوقه من مؤسسه التامين الوطني، لان مؤسسه التامين الوطني بتطالب في معرفه ظروف العمل وتقارير الطبيه الاوليه. بنطالب من العمالنا انهم مكان العمل اللي بتشتغل فيه صور موقع العمل، اعرف اسم المشغل اللي بتشتغل عنده، حاول يكون معك شهود يساعدوك في هاي القضيه. بنشدد على قضيه انه استخدم وسائل الامن والسلامه المهنيه في مكان عملك، طالب المشغل اللي بتشتغل عنده يوفر لك اياها، وانك ما تعمل في اماكن خطره كثير وفيها مشاكل. احنا بدورنا بنشتغل على زياده الوعي والنشر وتثقيف للعمال. هذا بنكون من خلال ورشات عمل بنقوم فيها مناطق السلطه الفلسطينيه، من خلال توزيع النشرات في المعابر المنتشره على مناطق السلطه الفلسطينيه. تحتوي هذه النشرات على توعيه لحقوق العمال، كيفيه التعامل مع اصابات العمل. كذلك بننشر في وسائل التواصل الاجتماعي مثل الفيسبوك كيف دير بالك، كيف حاله اصابه العمل ما عليك عمله. نعمل كذلك على محاربه ظاهره سماسه التصاريح. كثير من اصابات العمل لا يتم تحصيلها ومتابعتها بسبب ضياع المسؤوليه بين صاحب العمل الحقيقي وصاحب التصريح. اثنين بيحاولوا يتنصلوا من المسؤوليه عن اصابه العمل. وبشكركم على الاستماع لحديثي.
Thank you, Abed. And actually, thanks to all of our speakers. We're 10 minutes a bit late, but we still have time for questions for the audience. Let me actually check for a second what was already posted. This was an attempt to give insights from all of our different perspectives on the ongoing exploitation of Palestinian workers. And do we have all speakers on screen? Yes. Can you all hear me? I would like to start by addressing some of the questions, early questions that would stand here. And let's start for a second, since we've been mentioning a few of the lectures here, the middleman and the problems of the broker's fee. So Ronnie Perlman is asking, I guess, Kenneth, first and foremost, just some clarifications. Are the middlemen both Israelis and Palestinians?
They're mainly Palestinians from the West Bank. There may also be some Israeli Palestinians involved in it. I can't be certain about that, but I think the largest number are the from the West Bank.
And maybe a follow-up of Ronnie for the same kind of question of model of employment. Was there an attempt to actually enable Palestinians to get permits directly from not through the employers, not binding, which is part of what the reform was trying to do? Yes.
Well, the situation which I described has been in place for many years. So there was, as far as I know, there was never a time when the worker could get, the point would be to kind of liberate the worker from the situation. He or she would have to be able to get it to permit independent entirely of having a place to work. And then let's say you can imagine that person going to different employers to ask them whether they have work for them or not without the middleman. I think in this situation, there still would be a danger, if there were no law enforcement, of middlemen making agreements with employers to bring these workers and make the work more easily accessible to them. But that situation, allowing them to get a permit to work without any connection to the employer, would definitely strengthen their position. And that's one of the things that we are suggesting under the green card notion of permits.
Okay. I'd like to just remind the audience, this is your moment, because we will be closing already the application soon. So you have the link to send us questions. And we still have some time.
Khaled wanted to add something.
To add something, please. No. Sorry, Khaled, didn't see you there. Please. You have to unmute yourself.
أنا بدي أقول إنه ظاهرة السمسرة هي معظمها موجودة في أراضي السلطة الفلسطينية، يعني هن يعني توغلوا غاد وكل ما بيطوروا نفسهم وبيقدموا نفسهم. معظم الحالات تاعت السمسرة تدفع في أراضي السلطة الفلسطينيين، وبتدفع شهر بشهره، والمبالغ يعني هي بين 2000 ل 3000 شيكل شهريا. والسمسار بيوقع العامل على سند أمان في حالة إنه ما بيدفع المبلغ تاع السمسرة، يعني عمليا ومع سند أمان اللي بيقدر يقضيه بالمحكمة بأي محكمة فلسطينيين، أو عن طريق السلطة بحالة إنه ما بيدفع، عن طريق الشرطة بحالة إنه ما بيدفع بيجوا الشرطة وبيعتقلوا. في يعني من خلال شغلنا في المعابر وبالورشات لقينا اكتشفنا ظاهرة اللي هي كمان طريقة دفع عن طريق المشغلين. في كمان سمسرة اللي العامل بيشتغل عند نفس المشغل، والمشغل هو بيأخذ يعني سمسرة من العامل على أساس إنه بيشغل العامل وبيعطيه تصريح منه. يعني عمليا غير إنه بيشتغل عنده العامل، المشغل بيخصم منه السمسرة حق التصريح 2500 شيكل لحديد 3000 شيكل. الآلية اللي شرحوا لنا إياها العمال هي عملياً بما إنه العامل يعني يوميته الفعلية هي تقريباً 400 أو 500 شيكل، فوقت ما بيجي المشغل بيحاسبه على أنت اشتغلت مثلاً يا عامل 20 يوم، يوميتك 500 شيكل باليوم، بيطلع لك مني 10000 شيكل أجار شهري. فبما اني انا اعطيتك التصريح مني، بدي اخصم تكليف التصريح او تكليف حق التصريح اللي هو مثلا 2600 شيكل، فعمليا بيدفع له 7400 او 7500. يعني بشكل يعني وقت ما بيجي الحساب على الشهري هو بيخصم بشكل اوتوماتي حق التصريح. يعني هاي الظاهره يعني احنا واجهناها بشكل قليل يعني، بس موجوده. يعني المشغل الاسرائيلي ما بيقدر ياخذ نقدي من العامل مصاري انه يقول له انا مثلا هاي حق التصريح، ادفع لي حق التصريح بشكل مسبقا، الا وقت الحساب بيخصم من الاجر. احنا بنوعي العمال انه سجلوا، يعني صور المشغل.
خالد I'm cutting you short a bit.
شغلوا يعني خلي يكون عندك اثباتات لهي الاشياء، هاي اللي ظهرت بحكيها. شكرا.
Well, thank you. It is a complex reality check to understand. I'd like to maybe suggest you answer a bit more concrete also in the attempts of the audience to understand who are the workers. Two questions of Mohammed Hamdan that maybe Abed or Michal, you can give your insights. Who is asking what are the conditions of employment that employers require in order to work in Israel? And is there a health insurance for workers, for Palestinian workers? If we already mentioned questions of safety and their social rights.
جاوب.
تفضل عبد تسمع.
قانون العمل الإسرائيلي بيحدد إنه كل عامل فلسطيني بدخل بتصريح عمل في علاقة بين العامل والمشغل إنه مؤمن صحياً. مؤمن صحياً من ناحية إصابات العمل فقط. كل عامل فلسطيني معه تصريح عمل داخل إسرائيل هو مؤمن من ناحية إصابات العمل، وبالتالي أي إصابة عمل بتعرض لها العامل الفلسطيني هي من ناحية قانونية مغطى بإصابات العمل. لكن من ناحية مرضية عادية، مرض عادي أو يحتاج إلى علاج، هذا بتعالج في منطقة السلطة الفلسطينية، فيش له تأمين صحي زي المواطن الإسرائيلي. فالمؤسسة التأمين الوطني هي بتغطي إصابات العمل بالنسبة للعمال الفلسطينيين اللي بيشتغلوا داخل إسرائيل.
لو سمحت شيء ثاني أنا بدي أضيفه لو سمحت عناد، إنه بعد أزمة الكورونا وإحنا لسه موجودين بأزمة الكورونا، فمساعدة الجمعية ومساعدة ميخال يعني اللي هي اشتغلت بدل ما تكون بإجازة غير مدفوعة الأجار، اشتغلت على هذا الموضوع بشهر يعني قبل بسنة أكثر من سنة، اللي العمال اللي بيشتغلوا يجبروا إنهم يشتغلوا في داخل إسرائيل في مع وضع إن معين تصريح مبات اللي يقدروا يناموا بإسرائيل، أجبر المشغل الإسرائيلي إنه يأمنهم بتأمين صحي إسرائيلي زي العمال الأجانب. يعني لازم يكون العامل الفلسطيني اللي معاه تصريح شغل في داخل إسرائيل مع مبات إنه يكون مأمن إضافة للتأمين الفلسطيني اللي بغطيه في منطقة السلطة الفلسطينية تأمين صحي إسرائيلي اللي وظيفته إنه العامل ما بيقدر يرجع. كانت فترات اللي المعابر كانت مسكرة كليا، ما في لا دخول ولا خروج، فالعامل اللي بيعاني مثلا من وجع بطن من وجع راس بده يلاقي دكتور اللي يقدر يعالجه ما بغير مقابل. فبهاي الحالة المشغلين الإسرائيليين أجبروا إنهم يأمنوا العامل الفلسطيني تأمين صحي إسرائيلي زي العمال الأجانب اللي معهم تصريح مبات.
Thank you, Abed. Khadva Issachar asks us here an important question. Khadva, I would like to break your question into two and start actually with the ending and address it maybe to Michael, an attempt to be optimistic. And Khadva is asking, is there a chance to involve the Histadrut, Israel's biggest workers' union, in the pressure to implement the reform?
I am not a big fan of the Histadrut regarding Palestinian workers. The Histadrut has collected tens of million shekels every year from Palestinian workers as member fees, not exactly, even though at least in some of the cases, I don't know if 20% or 50%, but the Histadrut was not entitled to these fees anyway. She got it automatically from the payment unit within the Ministry of Interior, really 30, 40 years, and had no interest in doing anything in order to help the workers. I must add that until 2011, like 10 years ago, Palestinians were not accepted by the Histadrut legal frame as members because they are non-Israelis. There was a kind of a threat to the membership fees. And then the Histadrut created a special unit regarding Palestinian workers. They operated like for 3 years, I think. And then when the threat was actually, well, they stopped getting the payments automatically. Ma'an and us in Kav LaOved had a part of this change. We filed a petition against the automatic transfer of millions of shekels. So then they closed the unit. So basically, as I see it, I'm not very optimistic regarding the Histadrut's goals around the permit regime. I don't think they would do it. Anyway, it's also, as Kenneth explained, I think in the beginning, that the payments of the brokerage fees, some of it, at least some of it, are entering the employers' pockets. And the Histadrut, basically, especially in construction sector, does not really want to stand against the employers' interest. Thanks.
Thanks, Michal. So since we're reaching the end of our time, and I would like to maybe address part of what Khadwa asked in the beginning there about concrete proposals for change. And you touched a little bit upon it, Kenneth and Michal Korer, and you mentioned some suggestions of what can be done or what kind of pressure is put on the authorities at the moment. I'll add a second as a closing round, maybe. The notion that after hearing everybody speaks, it's hard, I think, to avoid the conclusion that under enforcement is a policy to itself. And we know it serves a lot of economic interests of different parties. And we also know the claim that it's Israel's national interest to enable the employment of Palestinians, and the quotas are raising constantly. There are some who will also claim that this is part of their strategy of avoiding escalation and tensions in the territories. But the state seems unwilling to change its under enforcement or promote a more efficient enforcement policies. So as active actors on the ground, And as I said, some of it you already mentioned, but I would suggest, we have here in the audience people from different embassies, organizations following closely. Maybe you can try to do a short round and summon what do you think can be concrete actions and pressure points that we're trying to move forward now in terms of implementations that will help protect the workers. And I would suggest we just go through like the speakers line we did before. Maybe Kenneth, you can start and just try all of you to be short, so we managed to do this in 7 minutes, all of us.
Yeah, okay. Very short. I think I've already mentioned the two main avenues of change which should be pursued. One is in organizing Palestinian workers in labor union situations or bargaining units, and helping them get into negotiations with employers. And this is a very difficult objective to obtain. There are a lot of obstacles to this, and getting the employers to recognize them, to talk to them. Often, I would point out, when Palestinian workers get involved in making demands on the employers fire them or somehow get their entry permit revoked, and the people can no longer come in. So the employers are holding a huge power over the workers. But the first thing is labor union organization, or at least organizing workers to bring pressure on employers. The second is law enforcement. I think these two things have to work together. And as you said, Einat, absolutely true that non-enforcement is a policy of ignoring the problem, of allowing the exploitation to continue. And I think the pressure has to be brought on the ministries, on the Ministry of Interior, the payments unit, the police, on other government ministries to change this. And I think it requires lobbying. It requires a strong interest group who can speak to these people and bring pressure. I'm not sure whether it can be done through the courts, but that is also an avenue that should be looked at. Thank you. Yeah.
Thanks, Kenneth. Khaled, maybe you can continue, but keep it short. I'm watching you. But if Kenneth already mentioned unionizing, maybe you can also say a word or two about the role of the Palestinian unions in addressing.
أنا بعتقد إنه يعني بدي أكمل اللي حكته ميخال بالنسبة للهستدروت. الهستدروت ما في حاجة إنه حدا يعزم عليهن أو يعرض عليهن إنهن يساعدوا العمال الفلسطينيين. الهستدروت بأخذوا مقابل من العمال الفلسطينيين سنويا بين 30 ل 40 مليون شيكل. يعني من واجب الهستدروت إنها ترجع للعمال الفلسطينيين مقابل اللي هي بتاخذه منهم. صح في اتفاقيات مع النقابات الفلسطينيين، بس النقابات الفلسطينيين هي ايديها مقيده وما في مجال انهم يتدخلوا في داخل اسرائيل، ان بيتدخلوا مع العمال الفلسطينيين في داخل اراضي السلطه الفلسطينيين. والعنوان الاولاني يعني بالنقابات هو الهستدروت هنا، بس الهستدروت عمليا زي اللي عبت ورقه يا نصيب، ورقة بايس، وسنويا بدخل عليها 30 أو 40 مليون شيكل من دون أي تعب ومن دون أي مقابل بالمرة. أنا حسب رأيي علشان العمال الفلسطينيين يعني يتحسن وضعهم، أنا بعرفش معند على هاي النقطة. أنا شايف إنه دائرة المدفوعات الإسرائيلية اللي هي مدار التشلومين هي عائق كبير حاليا في تحسين وضع العمال الفلسطينيين. دائرة المدفوعات هي عمليا هي عمالة بتسيء من وضع العمال الفلسطينيين. يعني تعمل تلوشات، يعني قسائم راتب للعمال الفلسطينيين اللي شو المشغل بيحكي، حتى بلا ما يطلب المشغل هن بيقولوا للمشغل انت هون نسيت تصرح انك انت دفعت له اجازه سنويه او ايام اعياد او كرنش تلمود، فلا اكتب لي ميل ثاني انه اندفع للعامل، وعمليا العامل الفلسطيني مقيد. ثانيا بيطلعوا قسائم راتب اللي العامل الفلسطيني بالمره ما بيشوفها، يعني ما بتوصل للعامل الفلسطيني في وقت اللازم. إذا العامل بيطلبها المشغل بيعطيها بعد بشهرين 3 وما بيقدر يفحص هاي قسيمة الراتب. الإشي الثالث لازم إحنا تكون في توازن بين بحث عن العمل. يعني العامل لازم يكون الإشي موفر له عن طريق ويب سايت، عن طريق يعني ويب سايت معين اللي العامل هو كمان تكون له إمكانية اللي هو يعني يبحث عن عمل ويختار بين 50 أو 100 مشغل، يختار واحد منهم. مش فقط لازم المشغلين اللي يختاروا عمال عن طريق ويب سايت أو عن طريق لائحة عمال موفرة، لازم يكون الإشي متبادل. يعني كمان العامل يقدر يختار المشغل تاعه، مش بس المشغل يختار. طول الوقت اللي الإشي موجود بإيد المشغل اللي هو يختار العامل، بهاي الحالة ظاهرة السمسرة بتضل قائمة وموجودة. شكرا.
Thanks, Khaled. Michal, I want you to try also to articulate some concrete. You've been practicing a lot also with Kenneth mentioned the attempt to mobilize through the court, the authorities. So maybe a little bit also about your experience and hopes or disbelief in what it can achieve.
I actually, what I wrote myself was not a legal way. On top of what Khaled and Kenneth says, one, I think not enough thought about idea, which I would really, I think has a lot of potential, is establishing a kind of an agreement between the Palestinian Authority in Israel regarding recruitment of workers, fair recruitment of workers, the kind of like a bilateral agreement we have with developing countries in migrant workers. I think there are other issues that can have a potential, a good potential to workers' rights regarding rights of medical treatments after work accidents. I think that there are a lot of problems the Palestinians are entitled to working to medical treatment after a work accident, but they are not necessarily able to enter Israel in order to receive them. I think there are in these aspects a lot of potential, and I do think that Israel and the Palestinian authorities has other agreements, even in economic issues, and I'm not sure that this is something that this is an angle that someone thoroughly checked, and I think the next step I would try this angle.
An attempt to be not optimistic but constructive. Thanks, Michal. Abed, maybe some thoughts about from the perspective on the ground. What are the tools that we can promote or demand that can help workers access their rights, be familiar to them? Some thoughts.
أول شغلة أنا بدي أشدد عليها في موضوع قسيمة الراتب اللي حكى عنها الأستاذ خالد وكنت، إنه قسائم الراتب لها دور كبير بيأثر على موضوع إصابة العمل في تحصيل الحقوق. فكل ما كانت قسائم الراتب حقيقية وبتعكس الأجر الحقيقي، تحصيل حقوق العامل بتصير فيها مبالغ أحسن وأفضل. وكل ما كانت أقل قسيمة الراتب من ناحية المستحقات بتأثر على هذا الوضع العامل في حالة إصابة العمل. أنا من ناحية اللي تحسين أو شو المفروض، احنا بالنسبة لي هي عملية الضغط على المؤسسات الرسمية، الوزارات اللي لها علاقة بالعمل، إنه يشددوا الرقابة، التجديد الإجراءات المتعلقة بالأمان والسلامة، من ناحية غرامات، من ناحية إغلاق المواقع اللي بتعاني من نقص وسائل الأمان لفترات طويلة. هاي بتساعد كثير على إنه يصير في تحسين لظروف العمال الفلسطينيين من ناحية إصابات العمل. كقضية احنا اللي بنشدد عليها اللي هي قضية زيادة الوعي والنشر وتثقيف العمال. كل ما كان العمال واعيين للحقوق اللي لهم، كل ما قلت ظاهرة إصابات العمل، وكل ما قلت عملية هضم حقوقهم. وبالتالي العامل اللي واعي واللي بيعرف الحقوق تبعياته ومتأكد من شو اللي بيطلع له في إصابة العمل هو أفضل من الإنسان ما بيعرف شيء. لأنه كثير من لقاءاتي مع العمال اللي أصيبوا في مكان عملهم، أول كلمة بقول لي أنا بعرفش شو القانون، ما بعرف شو الواجب اللي علي اسويه، وبالتالي عدم وعيهم لهي الحقائق لحقوقهم في اصابات العمل بتاثر على تحصيل حقوقهم. كذلك الامر مؤسسه التامين الوطني نفسها، انه في حالات كثير انه المشغل ما بتعاون مع العامل في تعبئه الاوراق المطلوبه، وبالتالي التامين الوطني بتهرب من هاي المسؤوليه. المفروض انه التامين الوطني يكون مساعد للعامل مش ضد العامل، لانه في حالات كثيره بتهرب من هاي المسؤوليه، وبالتالي الضغط على كذلك مؤسسه التامين الوطني انه في حاله انه العامل اصيب في مكان عمله وفي عندنا اثباتات رسميه وواضحه انه هذا العامل اصيب في مكان عمله، المفروض التامين الوطني يعترف في الاصابه ويكمل مع صاحب العمل في عمليه رفضه لتعبئه الاوراق وتعبئه المطلوب منه. كذلك الامر هي تحسين الوضع، اكثر شيء انه العامل واعي لانه اذا اصيب في مكان عمله انه لازم يجيب الامبولانس او يتوجه للمستشفى الاسرائيلي، يبلغ انها اصابه عمل، يحدد هذه الشغلات اللي بتساعده كثير في انه تثبت حقه في اصابات العمل وفي انه يحصل على حقوقه في نتيجه اصابه العمل. شكرا.
Thanks, Abed. Michal, this leads us to you. Abed closed also with emphasizing on the damage and the hardship when it comes to safety and protecting their lives. So maybe you can briefly, you mentioned it in your talk, and maybe you can highlight what's in the campaign against work constructions or for promoting the safety at the moment, are your highlights and demands and pressure from the authorities? You're muted, yeah? Michal, you're on mute.
I think Abed mentioned most things. I think that the important thing is training of Palestinian workers and making them part of this training and taking responsibility of that. Not only the authorities, like making the authority enable this kind of training. And I also think we should understand the connection between safety and work conditions. Okay, because I think we are talking about a whole way to treat a person. Okay, if your work is not stable, so probably your safety won't be stable. So I feel like we should, it's like it's combined tools. Besides all the things we said we are promoting with the authorities to increase safety. And I think we have to remember, and Michal said it in many ways, it's daily work. It's very low, it's very slow, but I think slowly things are getting better in a way. I want to believe that there's more visibility now than there was 5 years ago, and I really hope that it will get better slowly, and as much more people will join it and will make it visible, I hope it can change.
Thanks, Michal. I think we will end here. We heard a lot about the harsh, actually, reality of exploitation, about the disappointment, I would say, about the big reform that many have hoped will bring some profound change in the model of employment, and still as a way to go. But it's also good to hear that at least on some aspects, we feel there's more visibility, and maybe it will bring more pressure, and we'll be able to see a change. I'll say on behalf of Kav LaOved, it's the organization, and many others that were mentioned here, Ma'an, and Liep will continue monitoring the situation, sharing their findings. So we really thank you again for joining us and hearing our insights. I want to especially thank our interpreter, Bassem Thabit, that throughout the debate did his best to simultaneously enable Arabic and English here. So thank you, Bassem. Thanks you again to all the speakers and the NRC, the organizers of this event, and of course the audience that stayed with us. Hope to see you again.